here to announce that Judge Charlene Olmedo held David Anthony Burke, who goes by the name David spelled D4vd, to answer for the horrific and barbaric killing of a 14-year-old at the time, Celeste Rivas Hernandez.
That's DA Nathan Hawkman out of LA, talking after the conclusion of David's preliminary hearing. We are going to tell you what the court decided regarding whether or not this accused child killer is going to go to trial. And we just got a really big glimpse into what this defense may be. And I will tell you right now, it is shocking. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber.
They called it a preliminary hearing. In reality, it was a 5-day masterclass in prosecutorial demolition, and the target is an aspiring musician who turned a Hollywood Hills home into a slaughterhouse. David Anthony Burke, the artist known as D4vd, sat in that courtroom with a strange, detached smirk while the state methodically laid out why his life should end in a California execution chamber. The victim is Celeste Rivas Hernandez, 14 years old, dismembered, stuffed into the front trunk of a Tesla and left to rot in a tow yard until the stench of decomposition became a screaming confession. The judge just ruled there is enough evidence to go to trial on all 3 felony counts.
Into Tuesday morning.
Julia Dang, thank you so much for coming on. I really, really appreciate it.
So after I finished up with Julia, this is what came out of court. The judge found that there is sufficient cause to believe the defendant is guilty and to move this trial on all 3 counts, talking about how such a low standard it is. The judge reminded this is an exceedingly low standard, sufficient cause to hold someone to answer, again, probable cause. Apparently, David was staring straight ahead at the judge with his arms folded in front of him as she was reading this case, the law notes, court decisions. So yes, the judge found that there's sufficient probable cause. This is going to move forward. And it appears that an arraignment on these charges is going to be held on Monday, August 31st at 8:30 a.m. Bail has been denied, and there was also reporting from Julia that David was nodding rapidly as his attorney was whispering to him before waiving the speedy arraignment. So again, Monday, August 31st arraignment at 8:30 a.m.
Every single one. First-degree murder with special circumstances, mutilation of human remains, continuous sexual abuse of a minor. The death penalty is officially on the table. Here is the architecture of a nightmare. Prosecutors walked into court and immediately set the foundation with a staggering volume of digital forensics. We are not talking about a few suspicious texts, thousands of messages, explicit photographs, videos, the kind of evidence that leaves defense attorneys staring at a screen with nothing to cross-examine but the depravity of their own client. The prosecution's theory is surgical in its precision.
They were aware the 2 of them spent time together. But beyond that, we don't know if her parents were aware of this purported abortion that happened in January 2024. And let me just remind you, in January 2024, Celeste was still 13 years old. We don't know if her parents were aware that he was instructing her to take Plan B. We don't know if they were aware of who she was with, and what they were doing when she ran away from home, from her home in Lake Elsinore, at David's prompting. He called that OA. He had a name for those runaway operations. He called them Operation Awesome. He was talking to her over text in records that we've seen. He was talking to her about getting married, starting a family. He told her over text, you know, if you have twins, great, because we wanted 2 kids anyway. She was 13 years old when they were having those conversations.
David Burke spent years grooming this child, starting when she was 12, documenting the abuse, instructing her to take Plan B, orchestrating what he called Operation Awesome, to have her run away from home to meet him. When Celeste finally threatened to expose the entire operation...
him. Let me paraphrase for you some of this. In those messages that were shown to the court, that Detective Farrell read to us, Celeste tells David that she's going to ruin his career. She tells him that she's going to tell her father lies about him. She tells him that she has contact information for his business associates and for his mother. She tells him that she's going to call his mother, Colleen Burke, and tell her damaging information about David. Now, we previously have not seen these messages. We didn't really have a sense of exactly what was said in the argument between David and Celeste leading up to the night of April 23rd, when she allegedly died at his hands. So hearing this now and seeing all of this actually in print on the overhead monitor in the courtroom, it adds a little bit more color and life to
To
this.
contact his mother, his management, his business associates, prosecutors say David lured her to his house on April 23rd and executed her. The legal term for that is witness elimination, and in the state of California, it is a special circumstance that makes a murderer eligible for the death chamber.
Absolutely. I mean, that is child sexual abuse material. She references that. She talks about reaching out not only to David's mother, but people on his management team. So that speaks to two of the special circumstances in this case that make the first-degree murder charge eligible for the death penalty here in California. That's, of course, murder for financial gain. There was some back and forth just now about whether preventing financial loss constitutes financial gain. The prosecution is alleging that it does, in fact, count. And there are several cases here in California that set a legal precedent for that. This also speaks to another special circumstance under that first-degree murder charge, and that is murder of a witness to a criminal investigation. And the prosecution made it very clear just now in their closing statements that there did not need to be an ongoing or pending criminal investigation for that special circumstance to be applied.
The defense, however, just tipped their hand, and what they revealed is as audacious as it is desperate.
Applied. Here's where there might be an issue, though. Lying in wait. It seems to me, based on the text message conversations we were just parsing through in the courtroom, that Celeste was actually the one who demanded she and David have this meeting on the evening of April 23rd. She was the one who pushed him to have an in-person conversation. They were fighting about whether he was dating somebody else. She became very upset after seeing social media posts featuring the two of them. And it sounds like that was what triggered this argument. So she demands to see him. He tells her no. He's getting ready for a trip to Singapore. He says his parents are there visiting. He doesn't have time. She demands to see him. And finally, he gives in. So we previously did not know that about this argument. We thought that he arranged it.
They are floating self-defense. Let that land. According to the attorney sitting beside this man, the 14-year-old victim, whose dismembered body was found in pieces, was actually the aggressor. On cross-examination, the defense hammered a series of text messages showing Celeste was furious, jealous, and making threats. She had discovered David was involved with an influencer named Asia Collins.
I have to tell you, I was reading your notes. An interesting name popped up. Somebody that I was wondering if they were going to testify at this preliminary hearing. Somebody that we knew was a purported associate or friend of David. Somebody who created some social media video in anticipation of this case. And that is Asia Collins. We never really understood what her connection or role was to this. We sure did get a lot more information today about Asia Collins, didn't we?
We did, Jesse. Turns out Asia Collins, who is an LA-based influencer, social media model, she's got a presence and a platform online. Turns out it was her association with David and their rumored friendship or perhaps early stages of dating that made Celeste incredibly upset. And that is what Celeste cites as the source of her anger when she is threatening David and telling him over text the night before he sent the Uber to pick her up and deliver her to his home. She tells him over text that she's going to, quote, mutilate his. She tells him that she doesn't want to see one more instance of David being tagged in posts with Asia Collins. Asia did come out on the record and state publicly after the charges were filed against David that she never dated him. She also came out and says she wants justice for Celeste. Now, we don't know if she may be called as a witness during the trial, but her name did come up today, and we've been waiting to see what kind of role she played in all of this.
But again, this goes to this whole idea that's, right, the defense is saying Celeste was the one who wanted to come over. Celeste was the one who was dangerous. Yeah. Celeste was the one who was violent. Celeste was the one that was threatening him. And I appreciate where you said the court kind of put a limitation to that, but you're seeing where the defense may go if this
She demanded to come over. The defense wants you to believe that a 5-foot, nothing child posed such a lethal threat to a grown man that he was forced to kill her twice, with penetrating wounds so deep a medical examiner couldn't definitively identify the weapon. The court shut part of this down immediately. The judge ruled that evidence of supposed prior assaults by the victim was irrelevant and struck it from the record. The legal term is prior bad acts, and without a formal self-defense claim accepted at trial, it is inadmissible character evidence.
They are mounting, as far as I can see, and I think the court referenced it, a potential self-defense argument. I mean, when I'm reading these messages, there was an aspect to it, and correct me if I'm wrong, did Celeste physically, or are they trying to suggest Celeste physically threatened David, and that perhaps when she got to his house, he acted in self-defense? Am I looking at this completely wrong?
You're not. We've talked about a couple different defenses that attorneys have been, I think, either laying the foundation for or exploring as a potential option if or when this does go to trial. And I think this self-defense argument may be the one they have the strongest foundation for right now. As to the point you're making about physical assaults from Celeste, that was actually stricken from the court record this morning. The judge explained she is the victim here. She is not being charged with assaults. So until this goes to trial and the defense is presenting a self-defense argument, that's simply irrelevant. But that did come up.
The victim is not on trial here. The defense's foundation is already cracking. But here is where the narrative gets complicated, and you need to understand the gap in the state's case because it is the single breath of air keeping this defendant alive. There is no video of Celeste entering the house.
Potential
None.
surveillance footage, and the Uber driver. That may not be so helpful to the prosecution's case.
Absolutely. I was wondering last week, as the prosecution was calling their witnesses for this preliminary hearing, are we going to hear from that Uber driver at any point? You know, we've heard about that piece of the investigation for months now, that an Uber picked up Celeste in Lake Elsinore, where her family lives, and then dropped her off at David's home, just about 80 miles away in the Hollywood Hills. We haven't heard from this Uber driver yet. Well, that came up today in court. Apparently, LAPD did interview that Uber driver, and he denies having any recollection of that trip. He cannot definitively confirm that he dropped her off at that time, just after 10 p.m. that night, and he does not remember picking her up or driving her there. That is absolutely a hole in what the prosecution has been alleging for months now.
And no surveillance footage of her showing up.
The Uber driver who allegedly dropped her off that night has no memory of the trip whatsoever. LAPD interviewed him, and under oath, detectives admitted he could not confirm he picked her up or dropped her off. The security system at David's residence had overwritten its own footage by the time investigators accessed it. The hard drive simply cycled.
Things, right? Phone records, Tesla records, text messages that spell out what people were saying and doing at specific times. There is no surveillance footage actually showing David or Celeste going into or coming out of the Doheny Place home where he was staying at the time. The LAPD detective, Corey Farrell, the final witness for the prosecution during this preliminary hearing, he spoke to that today. And he laid out what I thought was a very reasonable explanation. He says by the time they tried to access that security system to search for that video, it had been so long, it had been months, and the system simply overwrote itself. It wasn't stored there anymore. Now, we don't know if somebody may have gone back and deleted that. We don't know if the cameras may have been turned off during that time. All we know is there is no video. So what the prosecution has been alleging this whole time, that David stood by and watched the victim bleed out, well, there's no video documenting that. So we have to wonder, Jesse, if they're going to call
whether that
another
was
witness.
neglect or a deliberate deletion, we may never know. The prosecution's timeline of the victim arriving at the property is built entirely on text messages and circumstantial cell phone pings. The defense exploited this mercilessly, arguing there is no direct evidence David was even inside the Tesla as it drove north toward Lake Kafuma, where Celeste's passport card was later discarded. It is a hole, a genuine evidentiary hole, and the state knows it. The prosecution's rebuttal, however, is a digital straitjacket. because while there is no video of the house, there is an unbroken chain of electronic movement. David's phone and the Tesla traveled together in perfect synchronization, leaving the property roughly 90 minutes after Celeste sent her final text message saying she had arrived. The vehicle stopped at a supercharger. The infotainment system logged it. Photographs of that screen were shown in court. The Tesla then continued to a remote area where months later, searchers located the victim's identification.
Where we just left off, when you got out of court to speak to us, the defense, I understand, had made a motion to basically say, hey, listen, court, there's insufficient evidence for this case to move forward. And as we're talking about, by the way, it's interesting. We've always wondered, why was there no grand jury indictment in this case? My mind is thinking, maybe there's an issue with some of the holes we're talking about. But talk to me about, if you can summarize, what have been some of the arguments from the defense today about why there's not enough evidence to support these specific charges, the elements of these charges, and what have you heard from the prosecution in response?
So what we just heard from the defense before breaking for lunch, Defense Attorney Marilyn Bednarski was laying out 5 issues that she has with the prosecution's case. Essentially, she is alleging they don't have any evidence proving murder. She says they only have evidence that can support concealment and transportation of a body. They also spent quite a bit of time attacking the 3 special circumstances surrounding that first-degree murder charge that make it eligible for the death penalty. It seems like there's a lot of focus on that, and of course that's lying in wait, murder for financial gain, or in this case, murder to prevent financial loss, which the prosecution has established is essentially the same thing, and murder of a witness to a crime, which the prosecution has established they can apply, even though there was no pending criminal investigation yet. So there's a lot of focus, I think, on invalidating those special circumstances and perhaps saving their client from the death penalty, which the DA, the LA County District Attorney Nathan Hawkman, hasn't actually decided whether or not they're going to pursue. There wasn't a lot of back and forth in the defense team's closing statement relating to the charge for which I think there is the most hard evidence for, the continuous sexual abuse of a child under 14 charge.
The state does not need a camera lens when the vehicle itself becomes a rolling black box, documenting its own driver's flight.
I was hoping you could amplify it, was this idea of tracking the movements of the car and the phone. That came up today, right, about David's electronic signature, electronic movements. Can you talk to us about that?
That's right. It came up again. This was from testimony that another LAPD expert spoke to a couple days ago last week during the first few days of this preliminary hearing. And in short, what that testimony established was that David's phone and David's Tesla were moving in the same place at the same time the night that Celeste was allegedly killed. So that came up again today, and they reminded the courts that as part of the prosecution's case, they found David's vehicle and his phone left his Hollywood Hills home at about 11:30 p.m., so about an hour and a half after Celeste arrived at that home, and then headed up to Lake Cachuma. Now, he went further north than that to charge his Tesla. It stopped at a supercharger location, and there were photos shown to the court today as part of the People's Exhibit of the infotainment system in David's Tesla. So that tracks, I think, without a lot of room for doubt, where the vehicle was. There's still a question as to whether there's any surveillance footage that shows David inside the car. Defense obviously pointed that out the other day. There is nothing so far that places the defendant definitively inside his car as it's moving away from the house up to Lake Cachuma, where the victim's passport card was found months later.
The medical examiner's testimony about the cause of death, 2 penetrating wounds, either of which could kill in minutes to an hour, also undermines the defense's claim that there was time to render aid. No 911 call was made. No emergency services were contacted.
The prosecution is they're assuming that happened because the argument would be there was no outgoing calls to emergency services. Although it seems to be complicated a little bit because the defense was saying your medical examiner, right, the medical examiner said that we don't know how long it took for Celeste to succumb to her injuries, right? So this idea that you claim our client was watching her bleed out, it seems that it's complicated by the ME's testimony, right?
That's right. I mean, he testified the other day, either one of those two penetrating wounds that they attributed her death to, either one could kill somebody in, quote, minutes to an hour. That is a pretty wide window of time. And he simply can't say, and that's because of the advanced state of decomposition. She may have been dead for weeks to months before her body was found. We saw in very graphic imagery exactly what her body looked like when the pieces were found in body bags inside that vehicle. So he can't say which penetrating wound happened first. It took them about 3 months just to finalize their autopsy findings and confirm her cause of death. So he doesn't know what kind of instrument or weapon caused those injuries. The body goes through a lot of change post-mortem.
Sure.
So
David Burke simply cleaned up, packed up, and drove north with a corpse in the front trunk. That is consciousness of guilt, and juries are instructed to weigh it heavily. The emotional core of this hearing, however, wasn't in the Tesla data or the legal sparring over the lying in wait statute. It was the moment Celeste's parents, Jesus and Mercedes, walked into the courtroom late around 10 in the morning and sat through the clinical dissection of their daughter's final
having those
hours.
Conversations.
And Celeste's family in court today was listening to all this?
They were. Her parents, Jesus and Mercedes, they walked in a little bit late. They came in around 10 in the morning, and they're sitting through this testimony. They're sitting there through closing statements. We feel their presence.
By the way, how is David acting and behaving in court today?
He's so interesting to watch, Jesse, because the responses, the reactions, I think you would expect from somebody in his position. We're not seeing those. I'm sitting at an angle, maybe about 15 to 20 feet behind him, so I can see from the side his facial expressions. You know, he walked in this morning, he was smiling, laughing a little bit, sidebarring with his attorneys. He's been sitting in his usual seat at the end of the counsel table, kind of staring straight ahead for most of today. He did start taking notes. That was something we didn't see during the first 3 days of this preliminary hearing, but he was jotting something down as they were going back and forth talking about the text message conversations. Beyond that, you know, we haven't heard much from him. He's very still. You know, he's not moving much. He's not fidgeting the way that he was on Friday when testimony was dissecting the child sexual abuse material found on his phone. But it's very interesting to observe him. I've had a couple hallway conversations during breaks with the courtroom sketch artist, and she agrees. I mean, in her words, she says...
The defense spent considerable time arguing that the family knew David and Celeste spent time together, that they allowed her to travel with him, that they may have been aware of the relationship. The implication is grotesque, that parental permission somehow mitigates the continuous sexual abuse of a child under 14.
Julia, I thought another interesting point was about Celeste's family. There seemed to be a big conversation today about what did they allegedly know or seemingly know about David's purported alleged illegal sexual relationship with Celeste, which, by the way, and we'll talk about this in a minute, the prosecution said even if there's this idea that David was mistaken about how old Celeste was, that's not a legal defense to the charge that he's facing. We talked last week about all the alleged imagery and photos and text messages potentially proving their sexual relationship, which is, you know, pretty disgusting to say the least, that whole conversation. But the point is, I have to bring it up. There was testimony today regarding what Celeste's family knew. And if I'm reading your notes correctly, did her parents walk in right as this was happening?
So to be clear, Jesse, as you stated, and the prosecution made this very clear in court today, several different ways, it does not matter how old Celeste told David she was. That does not absolve him of these child sexual abuse charges. It does not matter if she lied to him about her age and said she was 18 when she was 13. that does not change the factual substance surrounding that particular charge, sexual abuse of a minor under 14. It also does not matter that her parents consented to letting her travel with him. It also does not matter that her parents, her aunts, her cousins, and apparently her older sister were aware that she spent time with him, went to the mall with him, went to the movies with him. That does not make it okay for him to have sexual relations with this child. So that did come up. And I think that's part of this bigger story, right? We're getting a more colorful picture of what was happening around not only David, but Celeste. Yes, it does seem like, based on the evidence shown to the court today, people around her, including her family, they were aware.
The prosecution shut it down instantly. In California, a minor cannot consent. A parent's ignorance or even complicity does not absolve an adult predator. The statute is strict liability. If she was 13, nothing else matters. Not the fake ID she may have used, not the lies she may have told, not the family dinners or mall trips. The law draws a hard line, and David Burke crossed it repeatedly on video on his own phone. District Attorney Nathan Hawkman delivered the closing rhetorical blow outside the courthouse, standing beside his team with the controlled fury of a prosecutor holding a full house.
After the court's decision.
Good afternoon. My name is Nathan Hawkman. I'm the Los Angeles County District Attorney. Today I am here to announce that Judge Charlene Olmedo held David Anthony Burke, who goes by the name of a singer David spelled D4vd, to answer for the horrific and barbaric killing of a 14-year-old at the time, Celeste Rivas Hernandez. She has held him to answer for first-degree murder with the special circumstances of lying in wait, doing this crime for financial gain, and murdering a witness to an investigation. David Anthony Burke has also been held to answer for the mutilation of the remains of Celeste Rivas Hernandez on September 8th, 2025, and he has also been held to answer for engaging in continuous lewd and lascivious acts with a 13-year-old. What we have seen in this preliminary hearing, and the preliminary hearing was conducted by one of our most experienced deputy district attorneys, who is right here, Beth Silverman, and her team, working with the Los Angeles Police Department's Robbery Homicide Division. They methodically presented over 5 different days before Judge Olmedo the evidence that showed, and at this point we had to show it by probable cause, but by probable cause, and I would argue by an overwhelming amount of probable cause, and we will eventually prove this beyond a reasonable doubt. It followed the timeline of the interactions between Celeste Rivas Hernandez when she started as a 12-year-old, then a 13-year-old, then a 14-year-old who never got to see her 15th birthday. Because in the intervening time where she had these interactions with Mr. Burke, he engaged in this sexual conduct with a 13-year-old repeatedly, over and over again. This came out in text messages that were presented, in videos and photographs that were presented to the judge that showed this sexual activity. Ms. Silverman methodically tracked the timeline of their interactions during 2022, 23, 24, 25, that eventually led to the time where Celeste Rivas Hernandez went over to Mr. Burke's house in the Hollywood Hills on April 23rd, 2025, and has never been heard of again. But what Ms. Silverman and her team were able to show to Judge Olmedo is that on April 23rd, 2025, what actually happened was the brutal and horrific murder of Ms. Hernandez, and thereafter, over the ensuing 5 months, how her body was chopped up, left in the front trunk of a Tesla, only to be discovered on September 8th, 2025, after the car, and this is Mr. Burke's car, had been towed to a tow yard.
He made it clear this was only a fraction of the evidence, just enough to clear the extraordinarily low bar of probable cause. He reminded the press that preliminary hearings allow hearsay that the trial will demand admissible, direct testimony from forensic experts, medical examiners, and perhaps the very influencers whose names were dragged into this tragedy.
So the other idea that you need to have is that a preliminary hearing is not designed for the prosecution to present all its evidence. Mr. Quealy is correct from the Los Angeles Times that there was additional evidence that was actually considered in this case that we anticipate being presented at trial. I'm not going to go into the specifics of that additional evidence, only to say that we presented a significant but small fraction of our evidence in this preliminary hearing. At a trial, we will present all our evidence because the proof at a trial will be beyond a reasonable doubt. We will not be allowed to use certain hearsay that you can use in a preliminary hearing that you cannot use in a trial. It has to be admissible evidence, and the witnesses will need to come in to establish all the foundation, the relevancy, and overcome any objections to the type of evidence. So you are correct that there will be additional and significant evidence presented at a trial that wasn't presented here at this preliminary hearing. We'll take a question right here. We believe that the evidence at trial will be overwhelming to prove guilt beyond a reasonable doubt on the 3 charges with which Mr. Burke will be charged. You got a small preview of some of that evidence, including the text messages and the video and photographic evidence that was also presented directly to the judge.
He also stated in no uncertain terms that the state is ready for trial whenever the defense demands it. That is not bluster. That is a warning. The arraignment is set for August 31st.
These 3 felony counts that have already appeared in the complaint. August 31st will be the arraignment on that information. Thereafter, there will be a trial that will be set. That trial can be set as early as 60 days. And as we saw with the preliminary hearing, where the defense demanded that they have that preliminary hearing done within the time that the law allows, whatever time they want a preliminary hearing, we were ready. Often preliminary hearings in a case of this complexity take many, many more months than you have seen in this case. But when the defense demanded a quick preliminary hearing, we said, bring it on. And that's exactly what we did. If the defense wants a trial 60 days out or whenever they want this trial, we will be ready for that trial. So at this point, again, we don't have the one additional consideration is that Mr. Burke now is eligible for death penalty. The death penalty considerations are now being weighed. Part of that consideration will be any submission that the defense wants to submit to the district attorney's office. It is something that we will consider on whether or not we will see
the information will be filed. The Death Penalty Review Committee will weigh the defense's submissions, but the special circumstances, financial gain, lying in wait, witness elimination, are already stamped on the charging document. What remains is a portrait of a predator who believed his digital footprint was invisible and his celebrity adjacent enough to shield him. He took notes in court, laughing with his legal team as if he were workshopping a track list rather than facing annihilation. But the mask is off. The state has his texts, his images, his travel logs, and the recovered remains of a child he stuffed into a vehicle like Refuse. The system will grind forward now, slowly but with immense weight. And if 12 jurors see what the judge saw in that preliminary hearing, David Anthony Burke will not leave this alive. That is not a prediction. That is the logical endpoint of a case built on the bones of a 14-year-old who made the fatal mistake of threatening to speak. Subscribe, follow, and stay with this story. The trial is coming, and the evidence will be overwhelming.
So again, we have said this before, the unspeakable tragedy that the Rivas Hernandez family has had to go through to first lose their daughter, but to then find out how they lost their daughter is something that there are no words to do. All we can do at the district attorney's office is bring justice in this case by bringing that killer to justice. That killer is David Anthony Burke, and we intend to bring him to justice before a jury at a trial in the upcoming